In fact, go across to my colleague Pranesh immediately, who has the Prime Minister's tweet with him about what the Prime Minister has said. Yes, Pranesh.
Minister Modi hailing the Supreme Court verdict. Here's his post on X. He says today's Supreme Court verdict on the abrogation of Article 370 is historic and constitutionally upholds the decision taken by the Parliament of India on 5th of August 2019. It is a resounding declaration of hope, progress and unity for our sisters and brothers in Jammu, Kashmir and Ladakh. The court in its profound wisdom has fortified the very essence of unity that we as Indians hold dear and cherish above all else. I want to assure the resilient people of Jammu, Kashmir and Ladakh that our commitment to fulfilling your dreams remains unwavering. We are determined to ensure that the fruits of progress not only reach you but also extend their benefits to the most vulnerable and the marginalized sections of our society who suffer due to Article 370. The verdict today is not just a legal judgment, it is a beacon of hope, a promise of a brighter future and a testament to our collective resolve to build a stronger, more united India. Naya Jammu and Kashmir is the hashtag PM Modi has used. Siddharth.
Amit Shah, who had walked into Parliament on the 5th and 6th of August 2019 to announce the government decisions, has also now responded to the Supreme Court verdict. He said, and I quote, "I welcome the Honourable Supreme Court of India's verdict upholding the decision to abolish Article 370. On the 5th of August 2019, Prime Minister Narendra Modi ji took a visionary decision to abrogate Article 370. Since then, peace and normalcy have returned to Jammu and Kashmir. Growth and development have brought new meaning to human life in the valley once torn by violence. Prosperity in the tourism and agricultural sectors has raised the income levels of the residents of both Jammu, Kashmir and Ladakh. Today, the Supreme Court's verdict has proved that the decision to abrogate Article 370 was completely constitutional." That's the claim coming from the Union Home Minister himself, Mr. Amit Shah. Let's also go back almost 4.5 years ago when Mr. Amit Shah was in the Lok Sabha on the 6th of August 2019, and he made a categorical statement, which has of course also been part of a parliamentary resolution in the past, that Pakistan occupied Kashmir is an integral part of India. Let's listen to what Shah had said at that point in time.
कि जम्मू एंड कश्मीर के पीएको को आप भारत का हिस्सा नहीं मानते हो क्या? एग्रेसिव ना हो, जान दे देंगे इसके लिए। क्या बात कर रहे हो आप? एग्रेसिव होने की क्या बात कर रहे हो? जान दे देंगे इसके लिए। मैं ये बात रिकॉर्ड पर रखना चाहता हूं कि जब मैं सदन में जब जम्मू एंड कश्मीर राज्य बुला हूं, तब पाक ऑक्यूपाइड कश्मीर और अक्साई चीन दोनों इसका हिस्सा है, ये बात को।
The following are the conclusions. A. The state of Jammu and Kashmir does not retain any element of sovereignty after the execution of the instrument of accession and the issuance of the proclamation dated 25 November 1949 by which the Constitution of India was adopted. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. Article 370 was a feature of asymmetric federalism and not sovereignty. B. The petitioners did not challenge the issuance of the proclamations under Section 92 of the Jammu and Kashmir Constitution and Article 356 of the Indian Constitution until the special status of Jammu and Kashmir was abrogated. The challenge to the proclamations does not merit adjudication because the principal challenge is to the actions which were taken after the proclamation was issued. C. The exercise of power by the President after the proclamation under Article 356 is issued is subject to judicial review. The exercise of power by the President must have a reasonable nexus with the object of the proclamation. The person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. Once a prima facie case is made, the onus shifts to the Union to justify the exercise of such power. D. The power of Parliament under Article 356(1)(b) to exercise the powers of the legislature of the state cannot be restricted to lawmaking power, thereby excluding non-lawmaking power of the legislature of the state. Such an interpretation would amount to reading in a limitation into the provision contrary to the text of the article. E. It can be garnered from the historical context for the inclusion of Article 370 and the placement of Article 370 in Part 21 of the Constitution that it is a temporary provision. F. The power under Article 370 Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transitional power recognized in the proviso to Article 370, Clause 3, which empowered the Constituent Assembly to make its recommendations, ceased to exist. It did not affect the power held by the President under Article 370, Clause 3. G. Article 370 cannot be amended by exercise of power under Article 370(1)(d). Recourse must have been taken to the procedure contemplated by Article 370, Clause 3, if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. Paragraph 2 of CO 272, by which Article 370 was amended through Article 367, is ultra vires Article 370, Clause 1, Clause D, because it modifies Article 370 in effect without following the procedure prescribed to modify Article 370. An interpretation clause cannot be used to bypass the procedure laid down for amendment. H. The exercise of power by the President under Article 370(1)(d) to issue CO 272 is not mala fide. The President, in exercise of power under Article 370, Clause 3, can unilaterally issue a notification that Article 370 ceases to exist. The President did not have to secure the concurrence of the government of the state or union of the union government acting on behalf of the state government under the second proviso to Article 370(1)(d), while applying all the provisions of the Constitution to Jammu and Kashmir, because such an exercise of power has the same effect as an exercise of power under Clause 3 of Article 370, for which the concurrence or collaboration with the state government was not required. I. Paragraph 2 of CO 272 issued by the President in exercise of power under Article 370(1)(d), applying all the provisions of the Constitution of India to the state of Jammu and Kashmir is valid. Such an exercise of power is not mala fide, merely because all the provisions were applied together without following a piecemeal approach. J. The President had the power to issue a notification declaring that Article 370, Clause 3 ceases to operate without the recommendation of the Constituent Assembly. The continuous exercise of power under Article 370, Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President under Article 370, Clause 3 is a culmination of the process of integration and as such is a valid exercise of power. Thus, CO 273 is valid. K. The Constitution of India is a complete code for constitutional governance. Following the application of the Constitution of India in its entirety to the state of Jammu and Kashmir by CO 273, the Constitution of the state of Jammu and Kashmir is inoperative and is declared to have become redundant. L. The views of the legislature of the state under the first proviso to Article 3 are recommendatory. Thus, Parliament's exercise of power under the first proviso to Article 3 under the proclamation was valid and not mala fide. M. The Solicitor General stated that the statehood of Jammu and Kashmir will be restored, except for the carving out of the Union Territory of Ladakh. In view of the statement, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into two Union Territories of Ladakh and Jammu and Kashmir is permissible under Article 3. However, we uphold the validity of the decision to carve out the Union Territory of Ladakh in view of Article 3A, read with Explanation 1, which permits forming a Union Territory by separation of a territory from any state. N. We direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible.